Hey, good morning, everyone. My name is Harris Adams. I'm the administrative law judge assigned to hear proceeding number 24F-0236CP. This matter comes on for a hearing pursuant to decision R25-0037-I. Before I go much further, I should make sure. Tracy, are you with me?
I'm here.
Okay, making sure we're really on the record. Okay, good morning, everyone. And if we can start with taking entries of appearance.
Jedediah Knight, or Jedi Knight, if you will, for the complainant, Mountain Star.
Good morning.
Good morning, Your Honor. Sean Jennings with the law firm Ireland Stapleton on behalf of On Location Events. Also here is my co-counsel, Lidiana Rios, just in case I have to step out of today's hearing.
Good morning. Okay.
Hey, good morning, Your Honor.
I'm going to say, are you entering an appearance in this case?
No,
And I don't think I need to hear from you.
that's great. Thank you, Your Honor.
Thank you. Okay. Any preliminary matters we need to address before we get started?
Yes, Your Honor. We do have the matter of the motion to dismiss, which was filed by On Location.
Yeah, that matter was, I saw that motion filed a couple, 3 days ago. I think response time runs in about another week and a half.
That's correct, Your Honor. And we conferred on that and wanted to get Your Honor's opinion on whether you'd like to continue with this hearing now or wait for response and perhaps enter a continuance in this, just to see what your feelings are on that, Your Honor.
Matter set for hearing. I mean, if somebody's moving for a continuance, then I'll ask if there's objections and we'll roll on it. Otherwise, I think the motion to dismiss is not ripe for consideration at this point in time. And so I would plan to proceed with the hearing in absence of anything else. I mean, if the parties want to do something else, we can do something else.
Understood, Your Honor. Mountain Star is prepared for the hearing today and prepared to go forward and believes that's appropriate.
Okay. Anything further we need to address before we get going?
Your Honor, I guess I'll just respond since it's our motion. We do realize that it was filed shortly before the hearing. It was in light of Your Honor's ruling on federal preemption, and also acknowledge that Mountain Star has time to respond to that written filing. What Mr. Knight and I conferred about was essentially whether there are any outstanding factual issues that still need to be determined. So Ace and Ramblin have been dismissed from this case. The remaining parties are just On Location and Mountain Star. So if Your Honor, we'll be moving forward with today's hearing. All we would ask is that since our motion is based on subject matter jurisdiction, that we're not waiving any, we're preserving our rights and we're not waiving any of the rights and defenses that we have asserted in that motion. So again, I have discussed with Mr. Knight, assuming we did move forward with today's hearing, how it would look, but On Location just wants to make sure that we're not waiving any rights by going ahead today.
Well, and I think your motion's on subject matter jurisdiction, which you can't waive anyway. So, so I think we can proceed then, and that pleading will proceed in due course. All righty, Mr. Knight, then I think we're ready to proceed. You can call your first witness, and Ms. Crane or Ms. Federico, not sure who's driving, or are you guys ready?
Yep, we're ready.
Thank you.
We'd like to call as our first witness and only witness this morning, Rick Van Patten.
Okay, Mr. Van Patten, are you with us?
Hi, Your Honor. I'm here. I'm just trying to get my video to work.
Okay, take time.
I'm not sure why there's a exclamation mark. It's showing an error message on the video.
You want to take just a moment and reboot or anything? Try something different?
Yeah, if you don't mind, I'm going to hop in on a different browser.
Okay, thank you.
Yep, thank you.
While we're waiting for him, Your Honor, I don't know if Mr. Jennings had prepared any opening remarks, but I did. And if Your Honor would accept that, I'd like to give those opening remarks.
This case has been here a little while, but I would allow some brief opening comments. So you could proceed with that, Mr. Knight.
Thank you, Your Honor. So, and I will be brief. Just want to kind of, recap where we're at. In the, in Your Honor's decision on the motions to dismiss earlier, and we had extensive, long hearing and extensive evidence presented. Your Honor found that On Location is advertising to provide transportation services and advertising transportation services without disclosing that it is acting as a transportation broker. Your Honor also found On Location is advertising and offering to provide services without the necessary permits or authority to do so. So far, we have no presentation of any evidence by the other side, nor exhibits that were presented for this hearing regarding insurance, driver's records, service or maintenance records, anything like that. And these are all violations of Colorado law and the rules. And there's penalties set forth for that. We believe that the penalties are appropriate. There's cease and desist penalty and also monetary penalties. We believe that those are appropriate and believe that Your Honor would do well in determining what that should be based on the facts of this case. And that's where we're going to really go with our case today.
Thank you. Mr. Jennings, do you care to make any opening remarks? You don't need to if you aren't prepared to or don't want to.
Just a brief response, Your Honor, or,
Sure.
or opening remarks. So the way On Location sees this case, Your Honor, we see this case coming to sort of a natural conclusion. This was a complaint filed back in June of last year. So this proceeding has been going on for quite a long time. There's been a lot of work put in by the four parties to this proceeding. Essentially, the crux of the complaint that was filed involved service to Red Rocks that entailed a website provided by On Location, but most importantly, entailed underlying transportation service provided by Ace Express and Ramblin' Express. And as this case has developed, Your Honor, with Your Honor's ruling last week on federal preemption, and as we briefed in our motion, the entire crux of the complainant's case was that all three parties were operating unlawfully. They were engaging in some conduct that was out of compliance with PUC rules. And this entire record has to do with the chartered transportation service to Red Rocks. There is no evidence, and On Location does not provide any other, they're not involved with any other types of transportation in the state of Colorado. The entire purpose is getting folks up to see specific concerts at Red Rocks. And so, Your Honor, we think with the federal preemption ruling and a website disclaimer that On Location is voluntarily adopted, and we submitted that into the record as attached to our motion, that there really are no remaining viable claims in terms of Your Honor may rule in our favor. And if you grant our motion to dismiss, then this case would be over. There would be no remaining claims and remaining parties. And Your Honor, just briefly, I do want to comment on the fact that Mountain Star is still seeking civil penalties. The way I understand their theory is that they're seeking civil penalties for some sort of past conduct on the part of On Location. And the relevant statute here, Your Honor, is the statute, Your Honor, is 40-10.1-112 subsection 2. And that's the statute that allows any person to file a complaint against a motor carrier. And so that's the express language of the statute. I think that's the statute that that Mountain Star has appropriately filed when the case included transportation carriers Ace and Ramblin'. And since, Your Honor, On Location is not a motor carrier, it's actually been determined that they're a chartering party of 2 third-party providers, which are Ace and Ramblin', that operate pursuant to federal permits. We think that statute's actually quite clear that relief for Mountain Star would have to be against a against a motor carrier. That statute it does grant the commission, and we know the commission has discretion to fashion appropriate remedies in cases before it. But the remedies that are available to Mountain Star in this case are limited as against On Location. So that statute specifically addresses motor carriers, and the entire the other sections of that statute all relate to revocation or suspension of a motor carrier's permit. And it's undisputed that On Location doesn't hold CPCN authority, luxury limousine permit authority, doesn't hold any permits as a motor carrier. So we don't think that that statute allows it's not entitled Mountain Star to any sort of civil damages in this case. And then one other, Your Honor, besides the plain language of that statute, this issue actually came up very recently last year in another transportation case involving competitors, involving intra-business complaint proceeding where commission staff was not a party, so it was not a CPAN proceeding. And the judge in that case, which we cited in our motion, but the judge very clearly found that the complainant was asking the commission to issue fines, to issue civil penalties for some past conduct, and the judge determined that was not an available remedy in a case that just involved business competitors. The authority to fine utility does not extend to litigants, nor are penalties available in litigation between private parties. That's decision R240760. We did cite that in our motion, Your Honor. And then finally, because I think where Mountain Star is going as to its remaining claims against On Location have to do strictly with advertising and with the definition of a transportation broker and with advertising practices. And under those, those relevant transportation rules, the 6,000 series of the commission rules, those penalties all expressly deal with CPAN proceedings. And as we know, those proceedings are initiated by the commission. There's usually a deep dive into what penalties may be appropriate, if there are any penalties, and the analysis to arrive at a certain penalty, and whether the regulated utility would pay half the penalty, and waive its other rights. And so none of those factors are present here, Your Honor. This is essentially a commercial dispute involving business parties for transportation out at Red Rock. So in summary, Your Honor, we're happy to proceed with today's hearing. We just don't think, based on how this case is shaping up, that there are any available remedies left for Mountain Star. Thank you.
Thank you. Okay, Mr. Van Patten, were you able to make it back with us?
Yes, Your Honor. I apologize for the technical difficulties there.
That's okay. If I can ask you to first raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Knight.
Thank you, Your Honor. Mr. Van Patten, appreciate you being here today, and we'll try and make quick work of it so we can all get on with the rest of our day. First, I just want to confirm, it looks like you're in a room. Is anybody else in the room with you?
No, sir.
Thank you. I want to start with the RRX Shuttles website, rxshuttles.com. We saw exhibits of that back in September. I'm sure you're very familiar with it. Want to find out, how long have you been operating the website? By you, I mean on location.
On location, I mean, they must have been operating the website whenever they purchased CID, which I don't know the exact date of.
Can you give a rough estimate?
Well, it was before I started, and I started in 2022, so it was before then.
I can just ask you to tell me what CID stands for, if you know.
CID is the previous company. I believe it stands for Consider It Done. It's the company that used to own and operate all the programs that On Location currently owns and operates.
Thank you.
Yes, sir.
And about how many months per year does the shuttle, do you guys find that you're selling tickets and you operate these shuttles from, the locations in Denver to Red Rocks?
It's just for the Red Rock season.
Which is about how long is that?
It's about March through November. Yeah.
Do you know how much traffic that website receives?
I do not.
You have any estimate?
I do not.
You know how many ticket sales there are per month or per season through the website?
Your Honor, I'm going to object to this question. We and we have actually been through some of these issues in the discovery process. But in this proceeding, Your Honor, these are business competitors, and as such, there are some topics, there is some information that is basically not discoverable. We're not in a highly confidential proceeding, and so we object on the basis that anything that's not publicly available, there are already copies of On Location's website in the record. That's public information. But things that have to do with the back of the house, finances, the revenue, the sales of On Location, we don't think are discoverable in this proceeding, Your Honor. And that is Commission Rule 1101H that deals with confidential information used or disclosed for the purposes of business competition.
Your Honor, the relevance here is key, and particularly where there's possibly going to be a penalty applied in this case, and the PUC needs to know what the scope of the violation is and the breadth of it. It's certainly different if they sold 1,000 tickets versus they sold 100,000 tickets, and I have no idea what that number is. We're happy to perhaps do this, separately, highly confidential with just attorney's witness and Your Honor, and exclude other people so that we can maintain the confidentiality of this. But this is very relevant to, particularly to the scope and breadth of their violation of the rules or alleged violations.
And may I just respond, Your Honor?
You may.
So our contention, Your Honor, is that we understand Mountain Star would like this information, but it's actually protected. It's not discoverable because of Rule 1101H, that Mountain Star is a competitor. This is not a commission proceeding where the regulator is asking questions of a business party or a regulated entity. This information would be useful to Mountain Star to understand how On Location works, how it interacts with Ace and Ramblin'. And even if we went into a highly confidential session, which On Location, is not trying to elicit this testimony, I just don't think the rules allow Mountain Star to elicit this information.
Okay, well, if the objection is the rules don't allow it, I'll overrule that. I think the commission's rules incorporate procedures to address confidential information. They also allow um, information to be taken into the record under protections for confidential information. There's also, if those protections are not adequate based on facts and circumstances, the process is available in order to seek highly confidential protections as well. But I don't see that should be coming up right now in the middle of this hearing. I also believe that it's not clear the scope of the sales on that site and the relevance of the scope of those sales to the scope of this proceeding and the transportation at issue. I know from the prior hearing in this proceeding that the two actual transportation providers providing transportation services did consider aspects of this information confidential, and it came into the record under highly confidential protections. Excuse me, or I believe those were confidential protections and they were redacted documents, if I recall correctly. The record would tell me for sure. So I think that I will say I'm sure there is some relevance, but I think weighing the reasonable concerns of the business interests, protections are appropriate. It doesn't go to the liability. I think it's a factor of the aggravating, mitigating circumstances that could be considered if penalties are being assessed. But I think weighing that as to the pending question is tenuous enough that I'm not going to broach the issue. So I guess it is going to be on relevance grounds that I'll sustain the objection.
Your Honor, just so I understand, are you saying that presently not relevant, but potentially relevant in determining a penalty, if that's determined to be appropriate?
Well, I think in general, I think the nature of the business, the information that is already part of this case, describes the business and the activity and the Red Rock season and concerts. And I think that there is sufficient information to give consideration. I don't think that you've demonstrated the relevance of the sales of the rxshuttles.com website is sufficiently informative to that I'm going to impose on their commercial interests.
Understood, Your Honor.
And in the fact that this is coming up in the middle of this hearing.
Understood, Your Honor. I think that's fair. I'll move on then. Mr. Van Patten, something that's come up, and this was found, and I just want to revisit this once for the record in this hearing. When on-location orders service from Ace or Ramblin', it has exclusive control of that bus. Is that correct?
Sorry, can you repeat the question?
When on-location orders service from Ace or Ramblin', does it have exclusive control of that bus? The control of the origin, the route, the destination?
Your Honor, I'm gonna object. This is essentially calling for a legal conclusion. Mr. Knight is reciting factors from the law or the commission rule, I think it's fine to ask Mr. Van Patten factual questions, but I'm going to object because this is calling for a legal conclusion. And I also think it may have been, you know, one of the established facts in one of your honor's prior orders, either the October order or the one last week.
I think it is it may well be an established fact. Mr. Van Patten has not been established that he's an attorney, and thus couldn't provide a legal opinion anyway. I think the question is as to the nature of the transportation when Mr. Van Patten, if he is company representative working with the Ace Express or Ramblin' Express, if he believes he's in control of the vehicle during the provision of that transportation. So I'll overrule the objection. You can answer the question if you know, Mr. Van Patten.
Yes, Your Honor. When we book buses, we are in control of point A, point B. Does that sufficiently answer the question?
And
Knight.
thank you, Your Honor. Do you control the route? Do you tell them which route to take between?
Routes are based on traffic. So we can suggest routes, but we suggest a route. The traffic dictates which route they take.
Understood. Going back to the website, where does it state on the website, and I don't recall seeing this, that On Location operates the website? Or do you know if it does?
I'm not sure what you mean by that.
So the website rrxshuttles.com, is that owned by On Location?
Yes, I believe so.
Does it state anywhere on rrxshuttles.com or any of the pages that On Location owns and operates that site?
Not to my knowledge. On Location's branding is all over it, but I don't have it in front of me.
So would someone going to that website be notified that On Location is really the one who's operating this scheme, this transportation scheme?
We don't operate a transportation scheme.
But didn't you just testify that you control A, B, somewhat control the route? That you schedule buses? You have that on that testimony.
I'm sorry, I don't understand your question.
So didn't you just testify that you guys control point A and point B, pick up and drop off? That to some extent you suggest routes? And you just testify to that?
Okay. What's your point?
Well, my question is, didn't you just testify to that?
I'm not sure the relevance. I don't understand your question.
You can just answer yes or no.
Can you repeat the question?
Mr. Knight, the record speaks for itself for what the witness testified to. I think the inference, possible inference of the word scheme might be troubling for the witness. I think you might rephrase your question. Let's move on.
So what I'm wondering is when someone goes to the website and they're buying a ticket for for transportation, do they know that they're buying it from On Location?
I don't know what they know. I believe they would think that they're buying it from On Location because our branding's all over it.
Does On Location have any insurance for transportation? For providing transportation?
To my knowledge, we don't have any specific transportation insurance. There could be some that the company has for some liability, but I don't know. I simply don't know. It's outside of the realm of my role.
Does On Location keep any vehicle maintenance records?
No,
Do they do any driver background checks
no,
or check driver credentials?
no,
Does On Location perform any vehicle safety checks?
no,
Has On Location registered as a transportation broker with the state or the U.S. Department of Transportation?
Object, Your Honor. That is a legal question. Transportation broker is a defined term, and there is no registration requirement. So I'm going to object on legal grounds, and the question is misleading.
Sustained.
Does On Location operate a similar service under any other trade name?
no, not to my knowledge.
Okay, those are all the questions I have, Your Honor.
Well, Mr. Jennings, it would be friendly cross for you at this point, unless you had a clarifying question. Perhaps I'd allow it now. Otherwise, you can call the witness in your case if you wish.
Thank you, Your Honor. I guess I do have a procedural question for Mr. Van Patten. We have two exhibits that have been uploaded to our box.com folder. They have not been pre-filed, so I would need to have the testimony of Mr. Van Patten to introduce and elicit those. One is actually the website document that's already been discussed, and the other is a related document. So either I would do that now in a rebuttal posture, or I could just ask Mr. Van Patten about those when he's up next.
Well, let's. It's Mr. Knight's case right now, so Mr. Van Patten, thank you for your testimony. Please remain available to be recalled later in the case.
Yes, Your Honor.
And Mr. Knight, you call your next witness.
Just a couple questions for Mr. Roman Lysenko.
Okay, Mr. Lysenko, are you with us?
Yes, Your Honor. Hello, everyone.
Okay, thank you. If you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And I should ask, are you alone?
Yes, I am.
Okay, thank you. All right, Mr. Knight.
Thank you for being here today, Mr. Lysenko. Like to, if we could, present Exhibit 100, which has been uploaded to box.com and was previously filed as an exhibit. I'm sorry, I don't know. Is that me who would do that?
Yeah, no, we're coming. We're coming.
One second. Yeah.
Okay. Thank you. And I would just ask if opposing counsel has any objections. This was uploaded before, if they had a chance to review this, if they have any objections to this being admitted.
Mr. Jennings, any objection to the admission of hearing Exhibit 100?
We have seen the document, Your Honor. I would like to understand, the relevance, and so I would like to see what the testimony elicits about this document.
Okay, Mr. Knight, let's get some foundation.
Mr. Lysenko, you recognize this document?
I do.
And what is it?
This is my email to Rick Van Patten right past the meeting, just given some rules and regulations. So I did email it right after the meeting, case and desist meeting. And I specifically specified in bold that that on-location shuttles to Red Rocks cannot advertise on shuttle company. That's at the bottom of the first page, I guess. If we scroll down, it's in bold. In addition, it starts with, in addition, if the shuttles to Red Rocks as a broker, and they did include the rules. So I was trying to notify Mr. Van Patten. So we did met before, and Mr. Jennings already brought that meeting a couple of times. So we've met before. The purpose of that meeting was case and desist and explain Mr. Van Patten what they do wrong. Through that meeting, I did brought up names like Gary Gramlich, Vanessa Kondra. I provided the PUC information status, and I explained that they need to, what's they doing wrong. So I explained who they need to contact just to do it right. Then I did send this email in addition to that, just to point what's being done wrong. But it seems like it did not work. They still pursued with what they've been doing.
And this meeting, this is in reference to the meeting that you testified about back in September, correct?
That is correct. Yep.
And this email was you said in response to that.
It was, yes, follow up. I believe on the next day or maybe within like 2 days after the meeting. Yep, just to kind of summarize and explain what's wrong.
Your Honor, we move to admit Exhibit 100 to the record.
Mr. Lysenko, I'd like to get a little clarification of a couple things. The exhibit offered is a 2-page document that does appear to be an email. It also says there were 4 attachments comprising 1 megabyte. There's listed at the top of the first page.
Yes.
And I'm comparing the names of those documents to the content. So I see 44908.docx. Is that in fact an attachment of your common carrier authority referenced in the email?
No, actually, this is the attachments of common carriers for ACE certificates, ACE Express coaches, and in addition to that, it was transportation rules. The rules which I point, because with the rule that I used in the email, he can easily search, Mr. Van Patten can easily search via PDF file that certain rule and kind of read that rule. So I did include transportation rules, and I did include the ACE Express coaches, common carrier, and contract and charter scenic bus licenses into this email.
Okay, and that's the attachments reference to the email.
Exactly. Yeah.
Okay. Ms. Jennings, any objection to the admission of Exhibit 100?
Your Honor, I think a foundation has been laid, but we object to the relevance. Mr. Lysenko is essentially testifying as to the law, which is a matter for Your Honor and the commission to determine. So we would object on relevance grounds, not to mention that most of what Mr. Lysenko attached and references in this document has to do with Ace and Ramblin', who are no longer parties to this case. So we don't think it's relevant to the claims against On Location.
Okay.
I'll overrule the objection. Hearing Exhibit 100 is admitted.
Thank you, Your Honor. I just want to get this one point on this. You said that this was sent in response to your meeting with Mr. Van Patten. Did you guys talk about On Location's activities, and did you express anything to them about that during that meeting?
So I did explain what they do wrong. So Mr. Knight, can you please repeat the question, because I'm not really sure. Do you want me to summarize that meeting, or do you want me go into details of that meeting and kind of explain how did it?
Yeah, You mentioned cease and desist, and I guess what I'm wondering is whether this was an attempt to resolve the issue before filing a complaint.
Yes, definitely. So the purpose of the meeting was cease and desist. Then I know Mr. Van Patten and Mr. Jennings, they brought up questions about us mentioning through that meeting that at some point we're willing to sell our certificate, I believe. But it wasn't the point. The point was cease and desist. I did explain what's going wrong. We pretty much same age with Mr. Van Patten. We've been just chatting. He explained what's on location doing, that it's probably on the way out, and he's maybe will be interested later on just doing it on his own, that shuttles to Red Rocks, and maybe he will be. But we've been just chatting, talking about it. I did mention that I did explain how to obtain these CPCN licenses and explain about regulated monopoly. And I did mention that maybe at some point we will be willing and considering selling our license, but at this point they need to cease and desist. So that was the whole purpose of this meeting, is the cease and desist. So I'm not sure if I answered your question.
Yes, you did very well. Thank you. And that's all the questions I have for you.
Okay, thank you. Any cross-examination, Mr. Jennings?
Yes, Your Honor, thank you. Ms. Federico, or whoever is driving, could you please pull up our exhibit 200 from the box? So this is a copy of Mountain Star's website. I'll ask Mr. Knight if we should stipulate to this or lay a foundation.
Mr. Knight?
I'm going to object on relevance. They can attempt to lay a foundation, but I'd like to note that first.
Let's just go ahead, Mr. Jennings. You want to establish your foundation?
Mr. Lysenko, are you familiar with what this document is?
So it looks like it's our website, Shuttles to Red Rocks. I did not print it, and so I cannot speak of authenticity of this document, but it looks like it's our website.
When you say our website, is that Mountain Star's website?
Mountain Star Transportation, DBA, Red Rocks Shuttle. Yes, you're correct.
And are you the owner of that company?
Mountain Star, yes.
As the owner, are you familiar with the operations of the company?
Yes.
Are you familiar with the advertising and the public website of the company?
Yes, definitely.
Okay, Mr. Lysenko, there are 6 pages to this. I understand that you did not print this or upload it, but does it appear to you to be an accurate copy of your website?
I'll need to take time and kind of compare it. So I'm...
Okay, Ms. Crane, if you would, let's take a moment and just slowly scroll through the document.
And could you please, can we just stop and just go up to just by the green calendar? There is the paragraph. Just 1 second. Yep, we're good. Can we just keep going, please? Yes, looks correct. Yep.
Okay. And I only have a few questions, but I would ask for the admission of this exhibit.
We'd
Mr.
object.
Knight, any objection?
Yes, Your Honor, we object on relevance, not established how this is relevant.
Mr. Jennings?
Your Honor, Mr. Lysenko testified pretty extensively about his interactions with our client with On Location. He's already testified about On Location's advertising meeting between the two parties about their respective services. And so we think it's relevant in the nature of cross-examination on that testimony. It's also relevant to the defenses and mitigating factors in On Location's answer to the complaint.
I'll overrule the objection. Exhibit 200 is admitted.
Okay, and just a few questions. If you don't mind scrolling back to the top of the website. So Mr. Lysenko, at the very top that we're looking at, does your website list limo in the left corner?
It does.
And then to the right of that, does your website list the phrase bus to show?
Yes, it does.
And is your current trade name Red Rocks Shuttle?
Trade name, well, DBA, doing businesses. Yes, it is Red Rocks Shuttle. Yep.
Okay, when did you start using that name?
Because the purpose of this project is just shuttles to Red Rocks. We don't do anything else. We don't transport people. Our CPCN allows us to transport people from all over Denver County and Origin Hotel to Red Rocks specifically and back. So the purpose of this project is only shuttle to Red Rocks. That's all. So that's why we just using, and as I aware of, I was one of the companies that kind of holding that certificate. Not that many other companies have it. So.
Right. Mr. Lysenko, I'm just going to ask you when you started using the name.
You said when?
Correct.
When it was registered, or when once we obtain the CPCN, I believe. So once we obtain the CPCN, and we can go and check when it was obtained first, because I know there are modifications, removing, extracting some portions. But when we first got the shuttle to Red Rocks CPCN for shuttle service, that's when we started using the shuttle to Red Rocks name. I can just roughly guess maybe 2 or 3 years ago, but I need to check exact date.
Okay, I'm really just looking for an estimate is fine. So 2 or 3 years ago would be 2022.
I will need to check on that. Yes, probably 20 or 2023. Yes, 2022 or 2023. Not sure. I need to check exactly because we've got a couple CPCNs before to do tours to Red Rocks and different locations. So we've got some CPCNs before, so we need to check exact dates on that.
Okay. Mr. Lysenko, you talked about different services. We're looking at the front page of the website. It lists public shuttle and private car right here on the website. Is that correct?
That is correct.
And are those two different services under different commission permits?
That is correct. Luxury limousine, it has the LL permit, which we also have. It's a luxury limousine permit to provide private transportation in private vehicles when you sell out on per vehicle basis. And then public shuttle, it's a common carrier license, CPCN license that we also have, and we provide on per seat basis service.
But when a customer comes to your website, they see both of these services right here on the same page. Is that right?
Yep. And they can choose either to ride the limo with us, private car, or get the shuttle. You're correct.
Okay. In your experience as an owner operator in this industry, do customers know which PUC permit applies to their ride?
which PUC permits applies to that, right?
Right.
Your Honor, I'm going to object to this line of questioning. It's really not clear what's relevant. It looks like Mr. Jennings is trying to make some accusation of malfeasance on behalf of Mountain Star, and that's just not a question here. They have a complaint. They can bring it in a separate complaint. They haven't brought it up here, and it shouldn't be allowed to be inquired into.
I think you're outside the scope of the proceeding. I also think you're asking the witness to speculate. So I'll sustain the objection.
Okay, we can move on from this exhibit. Briefly, could we please pull up exhibit 203? And this has been pre-marked and pre-filed. This is a copy of a document from the Secretary of State's office. We could either stipulate or lay a foundation.
Any objection to the admission of exhibit 203, Mr. Knight?
Objection.
I'm sorry?
No objection, Your Honor.
Exhibit 203 is admitted.
Mr. Lysenko, does this look like a Secretary of State document that was issued to your company?
It does.
On number 2 down there, does the trade name say Red Rock Shuttle?
Yep.
And the filing date on this document at the very top up there lists November 2022. Is that right?
That is correct. Yep.
When did you become aware of On Location's business and the transportation out to Red Rocks that had the On Location branding?
More once we start operating, we kind of realized how many companies, and I don't want to draw a conclusion, but we noticed how many companies operate without the authorities. So once we, to answer your question, once we start operating, we've been actually seeing several companies. And On Location was one of them. So once we start operating and digging into more about advertising, doing research on and analytics on demand, so that's pretty much when the On Location came out.
Okay, and you testified earlier when you were talking about your permits that it may have been around 2022 when you got commission authority for Red Rock Shuttle. Is that right?
I'll need to check, Mr. Jennings. I'm not sure off the top of my head. We've been getting, the PUC, it's a constant work. So we've been removing some lines from that permit, adding. So I need to check when the shuttles to Red Rocks exactly been added to CPC and to our certificate.
Okay. If it was 2022, 2023, let's say, were you aware that On Location was involved in Red Rocks transportation during the 2023 Red Rocks concert season?
2023?
Yeah, the summer concert season.
Yes, yes, I saw several companies, yep, and On Location were one of them. Yep, you're right.
Nothing further with this exhibit. I may ask to pull up exhibit 201, please. So this is a different, this document has been pre-marked. This is a different section of the website, and I just have a few similar follow-up questions for Mr. Lysenko.
Your Honor, I think we're going to object on the same grounds, as at least to the extent that they would attempt to use this to make any claims or try and show something wrong done by Mountain Star, which is the only thing I can think that they're going to try to do.
Relevance, Mr. Jennings?
Your Honor, we're not trying to bring another complaint or claims. What we're trying to do here is assert our defenses, which include unclean hands, balancing the equities, and mitigation. And Mr. Lysenko has already testified, that he approached On Location about their business operations. And so we think that this is relevant to those issues.
Your Honor, as much as I'm aware, it's not a defense to say, well, somebody else was doing something wrong too.
Yeah, I think the relevance is tenuous as best, but it is his public website. And so I'll allow it.
Okay, thank you, Your Honor. I only have a few questions. May we stipulate to this or lay a foundation?
Mr. Knight, do you want to object to the admission of your client's website, or assuming he thinks this is what this is?
No objection, Your Honor.
Okay, Exhibit 201 is admitted.
Just a few questions, Mr. Lysenko. This looks like a page on your website, is that correct?
It does.
Does it say bus to show kind of right there prominently in the front?
Yep, it does.
And wasn't bus to show the name of a different transportation company?
It's a general term. So bus to show, we advertise because we provide bus to show to people. So we transport people in a shuttle, in a bus, in a motor coach. So that's what we advertise on this page. Same as shuttles to Red Rocks. It's a general term, or bus to show. It's a general keyword or term that most of the companies using when they advertise service to Red Rocks. And so we do.
So is it your testimony that there was never a different transportation provider that you're aware of that operated under the exact phrase bus to show?
Well, I know there is, as we start operating, we've learned that there are other companies like bus to show right there, but we're not trying to advertise them on this web page. So it's a general term, bus to show, and that's probably the reason why they use that term, bus to show, because they provide bus to show. We provide bus to show. It's a general keyword or general term that we advertise with, but we don't advertise them on this web page.
So who's the they? Who's the them that you're?
The company you're talking about, probably you saying that there is a bus to show company or brand somewhere.
That's my question. Whether you know if there's another company that was using that exact name.
Objection,
I don't.
Wait, Mr. Lysenko, Mr. Knight.
We just object. He's answered the question.
I'm not exactly sure of theirs. But I'm gonna sustain the objection. You can rephrase the question. Because use of a name is not necessarily a right to exclusive use of a name. And so if you're going to try to establish something based on that, I think we need to get something relevant. So maybe rephrase your question or move on, Mr. Jennings.
Well, and I can't recall if Mr. Lysenko has asked it, but it's a very direct question. Are you aware, Mr. Lysenko, that there was a different company using the exact phrase bus to show for Red Rock service?
I think you're assuming facts not in evidence, Mr. Jennings. You can rephrase your question or move on.
We can move on, Your Honor. Final exhibit for this witness is Exhibit 204, please. And Your Honor and Mr. Knight, this was a pre-marked exhibit in On Location's case. It is an email that, you know, bears the name of Mr. Lysenko and Mountain Star that was sent to On Location. So I'd ask if we could stipulate to this.
That's fine. That's fine, Your Honor.
Exhibit 204 is admitted.
So, Mr. Lysenko, you testified about different meetings and different emails. This email was sent.
Objection, Your Honor. He testified about one meeting and one email.
That may be right, Mr. Jennings. Maybe you can lay some foundation.
Right. I think the exhibit is admitted though, right?
The exhibit is admitted.
Okay. Mr. Lysenko, are you familiar with what this document is?
Yes, that's my email to RRX Shuttles.
Okay. So it was a while ago, but did you send this email? Do you recall sending this email?
Yes, I do.
Okay. And this was an email sent by you to On Location events.
Yes, exactly. To set up a meeting so we can just kind of see how we're gonna proceed. I just want to make sure that when we bring up all these questions, just want to make sure we stay professional. And that's what we agreed on that meeting, that we stay professional through the whole this process. We're not gonna take these fights to the streets, and our employees not gonna be kicking each other on the streets. We working side by side at the Red Rocks. So we had to meet and discuss, and that, I believe, that was my initial email to set up that meeting. Yep.
And at that meeting, did you and On Location discuss a potential business arrangement for Red Rock service?
Can you please explain what do you mean as far as business arrangement?
Well, what did you talk about at that first meeting with On Location?
So I did explain, like before I went, maybe I need to go into details, but we spoke about licenses, that what it takes to provide such a service. I explained what they do in Rome. I explained the statutes, provided contact information for PUC staff, Vanessa Condra, Gary Gramlich, so Mr. Van Patten can talk and learn how he can do that properly. We explained that they cannot provide that service, that they need to case and desist. And I know that it's going to be not easy meeting, because usually we would send out case and desist email. If we see a wrongdoer, we would just send case and desist email, because I guess maybe due to lack of staff, but PUC does not usually kind of go and check transportation companies right away. And that's why the On Location didn't allow it to operate for so long up there. I know it's not going to be easy meeting to explain Mr. Van Patten what they do in Rome. So I actually skipped on a phone call. I skipped on the email, and we actually set up a meeting so we can sit down and just talk about what's going on, what's wrong up there. So, and the purpose of that meeting was the case and desist.
Okay, so the purpose was cease and desist. Did you talk about a business transaction that may resolve the matter to your satisfaction if On Location and your company entered into a business transaction?
No, I never said that we gonna file a claim if you're not gonna do something.
That was not the question. The question, Mr. Lysenko, is whether during the course of that meeting you talked about a potential business transaction.
Yes, I did mention, again, like I explained before, we've been just chatting. The whole meeting was, I believe, like 45 minutes, I think, if I can recall correctly. So after I explained all these rules, how that works, Mr. Van Patten been telling me about On Location, that they don't care about this program, and they probably gonna be like they on the way out, and maybe he will be interested in proceeding with this project on his own, how he can obtain this license. I explained that it's a regulated monopoly and there is a burden of proof that the companies need to meet before they obtain, and that we will, and at some point we probably will be willing to talk about like selling our license later on, which is our route that we're servicing right now. And then he, so that we will be able, but it was just mentioned briefly. We never discussed the terms, price, rates, and like what's any details. That the thing which was mentioned at that meeting never been repeated again after the meeting. So we never discussed or talked or in details, or we never came back to that. So it cannot be even treated as an offer. I know Mr. Van Patten trying to probably stretch it as unclean hands right now, but I'm not sure if that can be treated as unclean hands, because it wasn't the purpose of the meeting. We've been just talking, and that was in details. We've been explaining. We've been just chatting and talking about it. So I'm not sure if I can just say that. Did I say we would consider in selling our license at some point? Yes, I did. Was it the purpose of this meeting? No, it wasn't.
Okay.
Did we discuss it in details? No, we did not. We never spoke about details on this. So that was pretty much it. But that's, I'm not sure if I answered your question, because I'm not sure if you're trying to ask broad. I just want to give you some details so you can.
Okay, I understand, Ms. Osenko. So after that meeting, it's undisputed that there was no business transaction. There was no buying and selling of licenses with your company and on-location. Is that right?
Of course, we never even talk about it again.
Okay, just yes or no. There was no transaction that was entered into. Is that right?
That's right.
And did you file the complaint against On Location after the March email and after the April meeting? Did you file that complaint in June of last year?
Objection, Your Honor. That's on the record already. The date and when it was filed is on the record. He doesn't have to.
I'll make it more straightforward. Forget about the dates, Ms. Lysenko. Did you file the complaint after the meetings that you just described?
Yes, I did.
Okay.
So I couldn't.
I have no further questions, Your Honor.
Okay, Mr. Knight, any redirect?
Yes, Your Honor. I'm just making a note. Remember my questions. Okay. First, Mr. Lysenko, and I hope you don't take this personally. Is English your first language?
No, it's not.
Okay, so when you say the word case and desist, do you mean cease and desist?
Oh, probably yes. So when they need to stop providing such service and advertisement, yes.
Okay. I just want to make sure that's clear for the record. When it was brought up, the potential that you were going to sell your license, what was Mr. Van Patten's response to you?
He was. We did not really even talk about it. It was so briefly. It was in contents of Mr. Van Patten was thinking about obtaining license for himself. So it was just briefly been mentioned. So I'm not sure even if he responded to that, or even if he thought about something like that. I'm not sure even if he. Well, obviously now I see that he noticed, but I don't think so. It wasn't any specific response to that because it was so.
So you wouldn't say there was like a flat out refusal?
Oh no, of course not.
Nor was there flat out acceptance.
No, I'm not sure even if it can be treated as an offer to be refused or to be accepted. It wasn't even offer. So yeah.
Did you file this complaint in response to that aspect of your conversation with them?
No, definitely not. It was in response of they didn't stop after that case and desist. That's how we usually proceed. We send out to your wrongdoer, we send out email, and I know email probably not gonna do any good in this case. So we set up a meeting. I explained. Then we send the email with all the rules and regulations. It did not work. They keep doing what they're doing, and then eventually we filed the complaint.
That's all the questions I have, Your Honor.
Okay. Mr. Lisenko, thank you for your testimony.
Thank you, Your Honor.
And Mr. Knight, you can call your next witness.
Well, no more witnesses, Your Honor. Rest our case.
Okay. Mr. Jennings.
Thank you, Your Honor. We would call Rick Van Patten.
Okay, Mr. Van Patten. I'll remind you to remain under oath. Thank you for staying with us. And
Yes, sir.
Mr. Jennings.
Good morning, Mr. Van Patten. I may ask a few things that were already covered, but just to be sure, can you tell us your current employer?
On Location Events.
And what's your current title?
Program Manager.
And can you just generally describe for us what On Location does in Colorado?
Yep, just the Shuttles to Red Rocks program.
And as part of those operations, do you have a relationship with Ace Express and Ramblin' Express?
Yes, we do.
And so in this relationship that you have, is Red Rocks the destination for all of the transportation that On Location is involved with?
Red Rocks is the venue for the destination, yes.
Is that the final destination?
It's a round trip ride, Mr. Jennings.
Okay. So do you go to Red Rocks and then let me ask another question, Mr. Van Patten. Aside from Red Rocks, does On Location is On Location involved with any transportation other than for Red Rocks concerts?
No.
And does On Location charter buses with any companies other than Ace Express and Ramblin' Express?
Not in Colorado, not to my knowledge.
And we've talked a bit about your website here today. Does On Location operate a website that is related to concerts and transportation to Red Rocks?
Yes.
And do Ace Express and Ramblin' Express actually provide that transportation to Red Rocks?
Yes, they do.
Do they own and operate the buses that drive out to Red Rocks?
Yes, they do.
Has On Location ever tried to hide from customers that Ace and Ramblin' drive and operate and own the buses that go to Red Rocks?
No.
And as the program manager, you know, to the best of your knowledge, would you become aware of any customer complaints about the service to Red Rocks?
We would hear about it.
Okay. You would hear about it if customers were upset?
We hear about it one way or another, yep.
Have any customers complained about the nature of On Location's advertising on your website?
No.
Have any customers complained about your relationship with Ace Express and Ramblin' Express?
No.
Prior to the complaint here that was filed by Mountain Star, has the PUC staff ever contacted you with questions or concerns about the service to Red Rocks?
No.
So they haven't contacted you at all?
No.
Have any other state or local regulators contacted you with concerns about the service to Red Rocks?
No, they have not.
Aside from Mountain Star, have any other transportation providers contacted you about concerns with the service?
No.
What about any other tour companies, travel agencies, or others that also charter buses? Have they ever contacted you with complaints about the service?
No.
And, just to drill down, has the PUC staff ever alleged that your website is not in compliance with PUC rules?
No.
At this time, Your Honor, I just have those two exhibits that I mentioned, and that will conclude the testimony. Those are start with exhibit 205 in our box folder. And Your Honor, this one was not pre-marked, so I'm happy to lay a foundation.
Okay.
Mr. Van Patten, are you familiar with what this document is?
Yes.
Can you tell us what it is?
Yes, that's our website.
Okay. There are 3 pages. It may help to just scroll down. And Mr. Van Patten, when you say our website, is this the On Location Events website?
No, this is the Shuttles to Red Rocks website for our specific program.
Okay. Is it that essentially we've been talking about for the Red Rock service with Ace and Ramblin'?
This is the website, yes, that we sell tickets from.
Does this appear to be a correct and accurate copy?
Looks good to me, first glance.
Your Honor, we would move for admission of this exhibit.
Mr. Knight, any objection to exhibit 205?
No objection.
Exhibit 205 is admitted.
And could we just scroll up to, well, Mr. Van Patten, let me ask you, is this where customers would go if they were interested in transportation of Red Rocks through your company?
This is where they would go to buy a shuttle ticket, yes.
Okay. And that's for the Red Rocks transportation?
Yes.
Okay. Is this your main webpage?
What do you mean main web page? Yeah, this is our own.
Yeah, websites have different pages and rabbit holes, but is this your main web page?
This is the home page for the shuttle ticket purchase.
The home page, sorry. Could we just scroll up to page 2, please? That's good right there. Mr. Van Patten, did On Location add a language or a disclaimer to its website?
Yes.
And are on page 2 of your website, are we looking at that disclaimer right now?
Yep, that's it.
If you're able to, I don't know if it has to be zoomed in. Do you mind just reading that?
Mr. Jennings, the document's admitted in the record and speaks for itself. So if you have a question about it, by all means, let's ask it. But he doesn't need to read the entirety of it. I'm sure Mr. Van Patten is capable of reading.
Thank
Okay.
you, Your Honor.
And is it your intention to keep this disclaimer up on your website?
Yes, we will do whatever legal tells us to do.
So, do you plan to keep this disclaimer up on the website?
Yes, sir.
Okay. No further questions on this exhibit. The final one is exhibit 206, please. And Mr. Van Patten, are you familiar with what this document is?
Yes, that's where someone would go to purchase a shuttle ticket from our website.
So is this a page that someone would access from the main page that we just looked at previously?
Correct. They would click on buy shuttle passes, then they would click on whichever event they need shuttle passes for. This looks like a specific event, and this is where they would go to buy shuttle passes for that specific event.
And this one's only one page, but does this look like a true and accurate copy of that ticket page?
Yes, if you don't mind just scrolling down so I can see the whole thing. Yep, that looks good to me.
Your Honor, we would move for admission of this exhibit.
Any objection, Mr. Knight?
No objection, Your Honor.
Exhibit 206 is admitted.
Mr. Van Patten, I just want to put this document in a bit of context. So you testified that that On Location is involved in transportation for concerts to Red Rocks throughout the whole summer. Is that right?
For the whole Red Rock season, yes.
The whole season, okay. And can you explain to us then what we are looking at here? Is this for a specific Red Rocks concert?
This is for an event, and these are for shuttle tickets for that specific event.
And if we don't mind scrolling down towards the bottom, did you place the same disclaimer on the ticket confirmation page here at the bottom?
Our team did, yes. Our team went through and placed it on every single ticket.
So would this appear in a similar fashion for all the other Red Rocks concerts on the website?
Yes, it would. It's been implemented.
And I won't have you read it. Is this the same disclaimer at the bottom of this exhibit that's also posted on the main homepage?
Yes, sir. That's the same one.
Okay. Thank you. I have no further questions.
Mr. Knight, any cross-examination?
Yes, Your Honor, and I want to say as a preliminary matter, I'm just asked this because I'm anticipating an objection to this. So Mr. Van Patten testified they did whatever legal told them to do. And I intend to ask questions about that, about who did that, what advice they were giving, that kind of thing. I believe
My recollection first is he said he would do whatever legal does tell him to do. It was a future statement. You can try your question.
my question is, did legal tell you to put up that disclaimer?
Objection. Your Honor, that is very clearly calling for attorney-client privilege information.
I'll
And
sustain the objection. I think you're muted. Oh, there you go. Okay.
I said I had to try. What kind? So you talked about complaints. What kind of complaints have you guys received from passengers?
I'm sorry. You're directing that at me? What type of complaints?
Yes, Mr. Van Patten. What kind of complaints?
I believe Mr. Jennings was asking about a specific complaint, if we had or hadn't heard it. I'm not really here to talk about what kind of guest service complaints we get.
What he asked, to my recollection, and we can go back in the record and look, was whether if there were complaints, whether you would hear about those and handle those.
Yes, we would hear if there was a complaint about the verbiage on our website, we would hear about it.
Would you hear and have you heard other complaints?
Oh, yes, sir. We hear complaints every once in a while. Oh, the bus was late, number of different things.
You ever heard any complaints about injuries or sickness or illness on the buses?
No, not directly. I've personally never heard any complaints about that.
About the drivers?
Well, it's actually a little outside of the scope of my role. We have a guest services manager.
Okay, but you're here to testify on behalf of On Location, right?
For what's in the scope of my role, yes.
So you're aware that On Location has designated you as their representative to testify today, right?
Yes, I'm aware. I'm here.
And so your job is to be prepared for this, correct?
Correct.
Your Honor, that's argumentative. I'm going to object.
I'll sustain.
This is a cross-examination, Your Honor.
Yeah, but let's get to the point. I was trying to move us along. He doesn't have to know everything about this company could ever be called to do just because you have him here testifying today. If you can explore his knowledge, and so you're free to do that.
Have you ever been made aware of any claims by any passengers against On Location? Mr. Van Patten?
Have I been aware of any claims made against On Location? What kind of claims?
Claims of injury. We'll start with that.
Objection on relevance grounds, Your Honor. The direct testimony did ask Mr. Van Patten about, specific issues that are relevant to this case, the website and interaction with regulators. Things that could have anything to do with customer grievances or physical injury are not relevant to this case.
You asked him about customer complaints, and he said if there were complaints, he would hear about them. And I think Mr. Knight can explore that testimony. So I'll overrule the objection.
Thank you, Your Honor. And to be clear, I'm trying to explore a question that Judge Adams asked at the first hearing. Posed it really to the attorneys, but it's a question about if there's injury, if there's an accident, who's responsible? Whose insurance? Who should have the insurance to cover that? So that's why I'm trying to find out, have you received any claims? Has On Location received any claims regarding injuries to passengers or sickness?
Not regarding the shuttle program, no. To my knowledge, no.
Okay. Do you guys have a process for handling those kind of complaints if they were to come through?
It depends on the complaint. Yes, we have a process for handling complaints.
What is your process for handling complaints of injury or claims of injury?
If we got a complaint of injury, I would probably refer to our in-house legal counsel.
That's all the questions I have, Your Honor.
Okay, Mr. Jennings, any redirect?
No, thank you, Your Honor.
Okay, Mr. Van Patten, thank you for your testimony. And you can call your next witness, Mr. Van Patten.
We have no further witnesses, Your Honor.
Okay. Rest, and Mr. Knight, any rebuttal?
No, Your Honor.
Okay, that before brings presentation evidence to a close, but I want to address a few things, council. So I'm noticing we did start again with exhibit number 100 today. And because there were previous exhibits we need to address and distinguish. So we had, with the previous hearing, hearing report from September 9th of 2024. We at that hearing had hearing exhibit 101. Oh, it's ironic. We may not have overlapped. 101, 103, 104, 105, 301, and 303. And today we have admitted into evidence exhibit 100, exhibit 200, 201, 203, and 204, and 205 and 206. So we actually do not have an overlap in numbers. It's just the date and hearing in which they were introduced. So I think that is okay for that. It's from here, we do have the pending motion. I'll look for responses to that in due course. As to today's hearing, I'd give the parties an opportunity to file a written statement of position if you want. I'm not sure that I find any specific issues that I would have you need to address. But I'll ask the parties if you want to file a written closing statement of position. We can set a deadline for that. Otherwise, it'll go to a decision.
Your Honor, I guess I would offer on location's thoughts. We don't necessarily think that, a further written filing is needed. I'm happy to make sort of a brief closing argument, given what we heard today and the pending motion.
Okay, I'm not going to take argument on the pending motion. It's not right. And
the just the conclusion of today's hearing.
Sure. Okay, Mr. Knight, thoughts?
I had planned on a written statement of position, mostly to be able to cite to law and quote law. I find that most useful in writing and easiest to digest.
Okay. Well, I'll have a deadline then for briefing. Mr. Jennings, if you're interested in a brief closing remark, being it was Mr. Knight's idea for an opening statement, we will give a brief opportunity for closing remarks today. If you would like to do that today, and if you do, then I'm going to allow Mr. Knight to go first as he has the burden of proof.
Okay, Your Honor, very briefly, and we will submit the written statement also.
Okay, then Mr. Knight, I'll give you that opportunity if you want to make any brief oral remarks in closing. Otherwise, I'll look forward to your statement of position.
I really just have one point. This hearing, there was no evidence offered in rebuttal to the factual findings from September 9th that we talked about earlier. There was some pointing fingers of maybe Mountain Star did something wrong, but that doesn't excuse On Location's activities. And they haven't now disputed those factual findings or shown why it was okay. And I think for this reason, it necessitates a penalty or cease and desist or whatever Your Honor finds appropriate based on the conditions. And the behavior and the time length and how much they've been doing or how much service they've been providing. And so that's what we'd ask. And of course, I plan to, in my written statement, cite to the rules and regulations that are relevant there.
Okay, thank you. And Mr. Jennings.
Thank you, Your Honor. You know, as this case is developed, it is clear that this case is coming to a conclusion. With Your Honor's ruling on dismissing Ace and Ramblin from this case based on federal preemption, the record is very clear that that service and that ruling is also applicable to On Location. This is the only service at issue. It's the Red Rock service, the website, and the underlying buses that go out to Red Rocks. So we think that this case can be dealt with as a matter of law. And then as to the kind of overall complaint that Mountain Star brought, the crux of the complaint was that these three parties were operating without authority. Authority is a defined term in the commission rules. It means a CPCN, a permit. And those issues are essentially moot. So we heard that Mr. Lysenko, you know, wrote an email, requested a meeting. All of those issues were actually found to be dealt with by Your Honor's ruling. And when it comes to the website disclaimer, you know, so there's not a permit, there's not an authority required to be a transportation broker. Transportation broker is a defined term in the rules. You can be deemed one, you cannot be one. On Location, you know, doesn't think a finding on that is necessary, but if they are deemed a transportation broker, then you know, the facts are in the record for Your Honor to decide how to proceed on that. With regard to mitigation and the issues that we went through with Mr. Lysenko, the reason for that was because we did raise those defenses. And we think that the statute is very clear. The complaint statute allows a penalty against a motor carrier. And we think that the commission rules, the 6000 series, allow complaints in the CPAN proceedings. And those just aren't available remedies to Mountain Star. So we would ask that, you know, Your Honor, close this proceeding, that there are no penalties available to Mountain Star. Thank you.
Okay, thank you. And then for written statements of position, reasonable for the parties, more or less? Any request on timing?
Just a little, maybe a week after the response to the motion to dismiss is due, Your Honor.
Look to confirm. Hold with me just a moment.
I believe that would be April 7th, Your Honor.
Well, then it doesn't matter when it is. Does April 7th work for you, Mr. Jennings?
Yes.
Okay. Any statements of position, then I'll look for those by April 7th, and the matter will be taken under advisement. Anything further we need to address today?
No, Your Honor.
All right. With that, thank you very much. We'll be in recess. Have a great day.
Thank you.